Hear ye, hear ye, hear ye, the court of the judicial something UNK business ethics is now in session. The Honorable Emily presiding, judging.
You may be seated. Alright, well, welcome to day one of the Enron case in Mr. Holman's class. My name is Emily Mike, and I'll be your judge today. Some pretrial matters we'll address now, and a reminder that pretrial matters are not judge jurors, so you can speak freely, counsels, of whatever questions you might have. One thing, since I'm a new judge and no one knows me of any of my judging tactics, please stand when you object, say your objection, and then if I sustain or overrule, it'll be done. If I say you may be heard, please explain your objection. And you normally, if I say that, please explain. I'll let co-counsel or the other counsel also argue back of why it shouldn't be an objection. Mr. Holman, do you have any other control matters?
I don't think so. Thank you.
Okay. Well, if there is no other pretrial matters from counsel, we will begin opening statements and court will resume. So prosecution, would you like to begin your opening statement? Yes.
Ladies and gentlemen of the jury, this case is about deception. The evidence will show that Enron's leadership, including Kenneth Lay and Jeffrey Skilling, knowingly misled shareholders, employees, and the public. Through press releases, financial reports, and presentations, they painted a picture of financial strength while concealing billions of dollars in debt. Special purpose entities were created to be not legitimate business tools, but mechanisms to hide debt and inflate earnings. Despite knowing the true financial state of the company, Enron's executives presented a facade of success. Kenneth Lay and Jeffrey Skilling stood before investors and boasted of Enron's dominance while they knew the company was on the brink of collapse. Mark Metz, an Enron attorney, facilitated these deals. Jerry Arnold, their financial expert, will try to justify these actions, but the evidence will expose the truth. You will also hear from Sharon Watkins, who bravely warned Enron's leadership of the looming disaster. Her concerns were ignored as the cover-up continued. Timothy Belden and Johnny Nelson will also testify about their roles in Enron's energy markets today. This trial is about a lack of trust. There should be trust that companies provide honest information, trust that employees are treated fairly, and trust that our financial markets operate with integrity, but Enron betrayed that trust. At the end of this trial, the evidence will be undeniable. Enron's executives knew the truth and chose to hide it behind the deception. We will ask you to hold them accountable, because in a fair society, those who deceive the public must face the consequences. Thank you.
Ladies and gentlemen of the jury, my name is Thomas Muldoon, and along with my colleagues have the privilege to represent the defense in this case. Let me be absolutely clear that in this trial, the prosecution must prove beyond a reasonable doubt that both Jeffrey Skilling and Ken Lay knowingly committed fraud. If they fail to meet this high standard, your duty is clear. You must find them not guilty. This case is not a case of fraud. Instead, it is a case of business collapse caused by market forces and risks that did not pay off. The prosecution, as they already said, will attempt to paint a story of deception. But when you examine the evidence further, you will see a much more complex reality. Enron, like any business, took risks. Some of these risks succeeded, but some of these risks failed. Failure, however, is not fraud. The accounting practices in question were not only common in the industry, but also fully legal under existing regulations. Furthermore, our clients had no intent to deceive. Ken Lay lost 90% of his personal wealth when Enron collapsed, which is hardly the actions of someone engaged in fraud for personal gain. Enron's downfall resulted from external factors, market shifts, investor panic, and the independent actions of certain employees, not a criminal conspiracy. The law requires proof of intentional fraud. Throughout this trial, the evidence will show the following. The accounting practices were legal and approved by both auditors and as well as the SEC. Both Lay and Skilling were visionaries who believed in Enron's future and acted in good faith. Some individuals at Enron acted for their own benefit and are now attempting to shift blame. To support our case, you will hear from the following 4 witnesses. Jeffrey Skilling, who will explain why he believed in Enron's success and how financial decisions were legally reviewed. Ken Lay, who personally was devastated by Enron's collapse, proving he had no fraudulent intent. Mark Metz, who will confirm Enron's strategies followed legal corporate practices. And finally, Jerry Arnold, a financial expert who will testify that Enron's accounting complied with industry standards. At the conclusion of this trial, we ask you to uphold the fundamental principle that guilt must be proved beyond a reasonable doubt. Enron's failure was a tragedy, but it was not a crime. We trust you to reach the only just verdict, not guilty. Thank you.
Thank you, Your Honor. May I make a quick note? I forgot pre-trial. Regarding the timing, you guys are keeping time, right? After each after each witness is done, we usually put the time left for each prosecution and defense. So you have 20 minutes each, a 20-minute bank of time to use up, and so we update that up here somehow. So, you can just give it to me and I'll update it for you.
Okay. I actually have another trial matter. All lawyers have permission to use the well, which means you can pace freely when asking questions. Although please ask permission before approaching the witness with an exhibit and approaching the bench me with an exhibit. I'll give this one.
Yep.
Okay. Thank you for opening statements. Prosecution, you can call your first witness.
We call Andy Fastow to the stand.
Please raise your right hand. You swear to tell the truth, whole truth, nothing but the truth. All right.
Mr. Fastow, can you state your name and occupation for the record?
Andy Fastow, and the Chief Financial Officer of Enron.
Mr. Fastow, can you describe your role as Chief Financial Officer during the ending years of Enron's leading up to its collapse?
I served as Chief Financial Officer of Enron, and I was responsible for managing the company's finances, reporting financial results, and helping develop structures to raise capital and manage risk.
And what were your primary responsibilities as CFO?
I was in charge of Enron's financial planning, reporting, and risk management. I was also pushed to be involved in off-balance sheet transactions to improve Enron's financial appearance.
Why did Enron push towards off-balance sheet accounting?
Because at Enron we had large earning goals and a culture that demanded that we hit those numbers no matter what. And the SPEs allowed us to meet those expectations, at least temporarily, by hiding liabilities and inflating earnings.
And can you reflect on your time or your performance as a gatekeeper at Enron?
As a CFO, I was pushed to maintain Enron's appearance by manipulating financial statements through SPEs that hid our liabilities and displayed that Enron was still earning money. I also skimmed $30 million for myself from transactions between special entities LJM1, LJM2, and Enron, which was not in the best interest of the shareholders, and I entirely regret that.
What was the purpose of LJM, and what was the purpose?
It hid debt off of the balance sheets, and it also manipulated earnings in which we created fake profits by selling Enron's assets at hefty prices to LJM. And we also did Enron's credit rating appearance by hiding their troubled financial conditions from banks, investors, and creditors by moving their liabilities to LJM, which allowed Enron to borrow money less difficultly.
Your Honor, permission to approach the witness with exhibit number 1.
You may.
Do you recognize this exhibit?
Yes.
Can you explain what this exhibit is?
Yes. So it was about LJM's investment in the partnership meeting, and it discussed why Enron needed private equity. It also discussed the investment possibilities with Enron, as well as focusing on acquiring energy and communication assets from Enron.
Did you create this exhibit?
Yes.
Yes. Your Honor, plaintiff moves to enter this exhibit into evidence.
Counsel, do you have any objections? Assuming that we all know these exhibits based off the class.
Could you please refer to who the exhibit is addressed to?
Yes, it's addressed to Andy Fastow, as well as Jeffrey Skilling is one of the guest speakers.
Did you submit this exhibit into evidence on Friday?
Yes, I did.
Can we see a copy of the exhibit?
Yes, you can.
Okay,
So counsel, no objections?
no objections.
And what exhibit is this?
This exhibit is a copy of Exhibit 1. It is a copy of LJM's slideshow for a partnership meeting where Jeffrey Skilling was in attendance. Now, can you, so you knew about this LJM partnership, correct?
Yes.
And who all knew about this LJM meeting in general?
All executives were aware of LJM and their transactions. In fact, Jeff Skilling was even a guest speaker at one of the LJM partnership meetings.
And how did Enron use SPEs like LJM to benefit themselves?
Yes, so we use those SPEs to manipulate the financial statements of Enron, and we created LJM1 and LJM2 to buy bad assets from Enron and make them appear to be earning money, and we moved all sorts of losses to those SPEs. And those SPEs were built on value from Enron stock, and when Enron stock lessened, it then shattered those LJM1 and LJM2s.
Your Honor, no more questions.
Cross examination.
Yes, Your Honor.
Oh.
It's 1448. Yes, sir.
Good afternoon, Mr. Fastow. Mr. Fastow, is it true that you oversaw the bankers, deals, and finances at Enron? Since your time at Enron, is it true you were indicted on 98 charges of which include conspiracy, fraud, money laundering, and cheating on your taxes?
Yes.
Did you knowingly approve transactions that misrepresented Enron's financial health?
Yes.
Isn't it true that you personally designed, then managed special purpose entities like LJM1, LJM2, the Raptors, which includes Talons, Chuco, the list goes on, to hide Enron's debt from investors?
Yes.
Your Honor, permission to approach witness 1 with what has been marked Exhibit A. Mr. Fastow, do you recognize these images? And Mr. Fastow, can you please describe the first image?
Your Honor, that is true
Yes, Mr. Fastow, this is a picture of you on money. And Mr. Fastow, what is the second image in Exhibit A?
It is me and friends celebrating the financial acumen at a big climbing trip.
Defense moves to enter Exhibit A into evidence.
Any objections, counsel?
Can we have a copy? Yes.
And this is marked as exhibit what?
Exhibit A.
No objections.
The jury accepts exhibit A at this time. The authenticity has been stipulated to.
Your Honor, permission to publish Exhibit A to the jury. What was your reasoning for creating money with your face on it? No reason? And would you say that printing literally your own money and celebrating business accoutrements, which by the way means good business judgments, was a good use of your time?
No.
Alright, well let's talk about why you're spending your time here today. The defense team now moves to bring Exhibit B into evidence. Your Honor, permission to approach the witness with what has been marked as Exhibit B.
You may.
I now ask you to refer what has been marked as Exhibit B. Mr. Fastow, do you recognize what Exhibit B is? And what is Exhibit B?
That I did engage in transactions and I did conspire with others and did not do my duties to Enron shareholders.
What does Exhibit B portray factors that impact your daily activities?
Yes.
Defense moves to enter Exhibit B into evidence.
Counsel, any objections?
No objections.
Your Honor, permission to publish Exhibit B to the jury?
Yes, the jury accepts Exhibit B at this time. The authenticity has been stipulated.
Thank you. Mr. Fastow, can you please read the highlighted lines that Exhibit B portrays on your plea agreement, starting with what is highlighted on point 9?
I understood Talon was set up as a way to conceal the poor performance of certain Enron assets and that the hedging of these assets at values set by Enron misled investors by fraudulently improving the appearance of Enron's financial statements.
Did you fraudulently improve the appearance of Enron's financial statements then?
Yes.
And Mr. Fastow, can you please read the second highlighted piece, which is point 11, starting with, it's under the self-dealing transactions section.
I also conspired with others to and did engage in transactions designed to enrich myself and others in violation of my duties to Enron shareholders.
So Mr. Fastow, is it fair to say that you profited upwards of $30 million based off these special purpose entities?
Yes.
$30 million. It's a lot of money. Would you consider your actions and engaging in these transactions a conflict of interest?
Yes.
The defense rests.
Any cross-direct or redirect questions?
No, Your Honor.
You may sit down. Prosecution, you may call your second witness.
Prosecution calls Johnny Nelson to the stand.
Hey, Johnny, come here. Raise your right hand. Swear to tell the truth.
I do.
Good enough.
To start, what was your position at Enron?
I was a pipeline worker
And how long did you work at Enron for?
for about 21 years.
Yes. And what did Ken Lay tell you to do with your retirement stock portfolio?
He basically pressured us to buy stock. He told us that Enron was the stock to buy, and there was this culture at Enron that if you weren't investing into Enron stock, then you're almost seen as an outsider.
Your Honor, permission to approach the witness that has been marked Exhibit 2. Mr. Nelson, can you please read the highlighted portion of this exhibit?
Talk up the stock and talk positively about Enron to your family and friends.
And how did you feel after learning that Mr. Lay had sold millions of his Enron shares the same day of that meeting?
I felt betrayed. He told us that the stock was gonna rebound and he made everybody feel good about their stock, all the employees. I don't understand how he could do that, because if he was selling it behind our backs, then he obviously had information that none of us did.
Yes, and how did you,
Do you wanna enter this?
oh, yes, sorry, thank you. Plaintiff moves to enter Exhibit 2.
Any objections, counsel?
This is the article from the LA Times, correct?
Correct.
Objection, Your Honor, prejudicial effect. This article could create unfair bias and is leading.
And you may be heard. Explain a little more.
It creates unfair bias because the defendant or a party in the trial particularly is exhibit is particularly being used to exhibit a wrongdoing and is by an author that has a bias.
And your response, or counsel? Next.
You're gonna come to me.
Yeah, I'll hear response and then I'm gonna.
Okay.
review.
This is just a quote from the electronic forum for the, like, what was told in there, so, I mean, a quote's a quote.
Are all exhibits supposed to be entered? I know I got the email about it. Am I supposed to allow all exhibits or can I not allow something?
You can not allow it if you want to. We definitely don't allow it if it wasn't submitted, if you didn't get it, for sure. But anything, that you got a copy of and I got a copy of is a possibility, but you're still allowed to rule on it however you want.
Two things. One, I think council, you would need to lay a little bit more foundation of who wrote this author, when this was published. And then for the purposes of mock trial competition, she could, give her opinion how she felt. Otherwise, everything else said in that article, if that was not written by her, would not be submitted to evidence.
I see, okay.
So let's maybe backtrack a little bit, try to lay more foundation of who wrote it, and then if it's not applicable, then you can obviously object again, and I can sustain or overrule. So let's lay a little bit more foundation.
Okay. So, this article was created after the trial by Michael A. Hiltzik and E. Scott Rickard, from the LA Times.
Council, remember to ask your witness about this argument.
Okay, can you tell us a little bit more about, Exhibit 2?
Basically, it's just giving the quote of what Lay was telling us on an electronic forum in September. Basically, just telling us, as it says, to talk up the stock to our family and talk positively about it.
Yes, and what does the highlighted portion have to do with your, statement today?
So I was bused to Kansas. I originally was based in New Mexico, and
Objection, Your Honor, narrative.
I'll sustain and maybe tweak it with, relevance too, but I will sustain the narrative.
so we were bused to Kansas.
Council,
That makes
next
you-
question, or ask
Means you
another
don't answer.
question.
So, we will just, skip over that. How much money did you have in your retirement fund at Enron?
About $500,000,
Okay, and how much of that did you lose?
basically all of it.
Awesome. No further questions.
I would
We're
like
gonna
to
do-
note that the exhibit 2 will not be entered
Okay.
at this time.
Yes.
Cross-examination, you may proceed.
Thank you.
Make sure you're talking side for their side.
Mr. Nelson, how much money did you say you had in your investment account that was lost at the time of Enron's collapse?
About $500,000.
And Mr. Nelson, you had the option to diversify your investments at any time, correct?
I did, yes.
Before you moved your 401k entirely into Enron stock, did you consult a financial advisor or seek independent investment advice?
I did not.
Are you aware that other large corporations have also experienced sudden declines in stock value impacting employees in similar ways?
I was not aware of that.
So you're not aware that any other large corporation has ever failed and thus impacting employees similarly than Enron did?
I don't think that a lot of large corporations have committed fraud and lied to their employees.
Okay, moving on. Do you acknowledge that Mr. Lay, like many executives, had confidence in his company and was working to stabilize it?
I'm sorry, could you repeat the question?
Do you acknowledge that Mr. Lay, like many executives, had confidence in his company and was working to stabilize it?
I believe he had confidence and was trying to stabilize it, yes.
Okay. Mr. Nelson, you mentioned that your opinion is that Mr. Lay lied to you. However, you are not an expert in anything corporate finance or securities laws, correct?
That's correct.
Can you say with certainty that Mr. Lay knew the company would fail at the time that he made these statements to you guys?
I can't say with certainty, but he did sell his stock that night, that evening, after we had been bused to Kansas, after he had told us to trust Enron and believe in it and it was going to rebound, yet he was selling it that night.
So you're claiming that Mr. Lay sold his stock the same day that he was pressing you guys to keep your stock?
The same day as when we were bused to Kansas.
Okay, and do you have any evidence of that claim?
We do not.
No further questions, Your Honor.
Any redirect questions? this could be a time to reiterate your point hard in just a couple questions to prove your side again. No further questions, counsel?
No further
Okay, you may sit down. Prosecution, you may call your third witness.
Prosecution calls Timothy Belden to the stand.
Give an update for our time, please.
Yeah.
Whoa.
Okay, plaintiff is at 10:27 and defense is at 13:06.
Thank you. Good job. Raise your right hand. Do you swear to tell the truth, whole truth, nothing but the truth?
Yes.
Okay.
Please state your name and occupation for the record.
My name is Timothy Belden, and I was a West Coast energy trader for 12 years at Enron.
What was your role at Enron?
My role was to manage energy trading in California and other western states, and my team took advantage of price fluctuations in the electricity market to make profits for Enron.
And how did California's electricity market function at the time?
After the deregulation, the California energy market was volatile. There were structured flaws that allowed Enron to exploit price fluctuations for massive profits.
And how much money did Enron make from these trades?
In 9 months between late 2000 and mid 2001, Enron made almost $1 billion.
And do you believe that Enron did these transactions illegally or against the California law?
At the time of the system, I believe.
Objection, Your Honor, leading.
I'll overrule and maybe you're on the right track, just wrong objection.
Can you repeat the question, please?
Do you believe that Enron was abusing California's laws at the time?
I do.
You do? Okay. What was the main driver for the profits of Enron at the time?
The main profit driver came from price volatility, not increased volume. Enron capitalized on price swings and market manipulation strategies rather than simply selling more electricity.
No further questions.
Cross-examination. And jury, can I just note that actually I would have sustained that. That was another appropriate objection. I was just thinking of a different one, so please award points for that objection.
Your Honor, permission to approach the witness with what has been marked as Exhibit C.
You might.
I ask you to refer to what has been marked as Exhibit C. Do you recognize Exhibit C?
Yes.
And what is Exhibit C?
It's a agreement.
Okay, and Your Honor, permission to give the exhibit to the jury?
You may. But not to publish, just for them to see right now.
Your Honor. So Mr. Belden, can you go to page 3 in that plea agreement for me? And read the entirety of the sentence that contains the highlighted part in paragraph number 2.
Beginning in approximately 1998 and ending in approximately 2001, I and other individuals at Enron agreed to devise and implement a series of fraudulent schemes through these markets.
And will you also read the other sentence that's highlighted right there for me, please?
I agree to waive all right, title, and interest I have in $2.1 million I received from Enron, which funds I acknowledge the government contends represents a proportional amount of compensation paid to me by Enron attributable to the scheme to defraud to which I am pleading guilty.
Your Honor, permission to enter Exhibit C into evidence?
Counsel, any objections?
Can we
I get a copy?
Do you guys have any objections?
No objections. The jury will enter exhibit C at this time, the authenticity has been stipulated to.
Thank you, Your Honor. So since you entered into a plea agreement, you understand that the government has the responsibility of determining whether or not if you provided substantial assistance in today's court, correct? And I can define substantial assistance if you'd like.
That's correct.
Just for the jury and everybody here, substantial assistance is defined as the involvement a defendant offering credible information or assistance that significantly furthers federal authorities' efforts to prosecute other crimes. Hopefully that makes sense. So, in other words, your ability to receive a reduced sentence depends on helping the prosecution secure convictions in this trial, doesn't it?
That is correct.
Would you agree that under this agreement, you have every incentive to shift blame onto higher level executives in order to help your own situation?
Objection leading.
Well, cross is supposed to be a little bit of leading, because they want to say yes or no, so I'll overrule at this time.
Could you repeat the question?
Yeah. Would you agree that under this agreement, you have every incentive to shift blame onto higher level executives in order to help your own situation?
I feel the blame is already there based on your actions.
Yes or no?
No.
Mr. Belden, as part of your plea agreement, you agreed to forfeit $2.1 million that you personally made from Enron's trading schemes, correct?
That is correct.
Would you agree that the more Enron profited, the more money you personally took home?
That is correct.
But nowhere in your plea agreement do you state that Mr. Skilling, or Mr. Lay instructed you to engage in any fraudulent schemes, is that correct?
That is incorrect. It seems like it was the culture of the company influenced by our leaders, which were just.
So, in your plea agreement, is it ever directly state Mr. Lay or Mr. Skilling's name anywhere in the entire plea agreement?
I don't believe so.
It does not. In fact, the agreement refers to you and others at Enron, but it never names any senior ranking executives. Is that correct?
Correct.
Did you ever consult with senior executives such as Jeff Skilling or Ken Lay about your trading strategies before implementing them?
We were told to make as much profits as we could by manipulating the market.
And who told you that?
That was given, based on the culture of the company and the way that they ran it prior to.
Okay. Do you or your counsel have any documentation, emails, meeting notes, or any actual hard evidence that shows that Enron's top executives directly authorized or even aware of these trading tactics that you implemented?
No, I don't believe so.
So in a few words, how would you explain your role as the managing director of Enron's West Power Trading Division, which oversaw California?
It took advantage of the volatile market.
Took advantage of the volatile market. So would it be fair to say that you weren't simply, sorry. Can you explain your role again for me? I'm sorry.
My role was to manage energy trading in California and other western states. My team took advantage of price fluctuations in the electricity market to.
Objection, ask and answer question.
Normally I would sustain, that's a good objection. However, I think, our counsel was just trying to regain his footing and just relay it. Otherwise, that is a great objection.
Okay, so would it be fair to say that you weren't simply following orders, you were actually creating strategies and implementing strategies yourself?
Yes.
That is all my questioning. Thank you, Your Honor.
Any redirect questions?
No, Your Honor.
You may step down. Prosecution, do you have any more witnesses you'd like to call to the stand?
Yes, prosecution calls Sharon Watkins to the stand.
6 for Sevener.
Okay, for defense it's 7-11. For plaintiff, it is 8-10.
I do.
Oh, good enough. I believe you.
Could you please state your name for the record, please?
My name is Sharon Watkins.
Awesome, and can you walk us through your qualifications for working in such a high position at Enron?
Yes, I worked for 8 years at Arthur Anderson as an auditor. I then moved to GM Trade where I worked with their finance-based commodities. And then in 1993, that's when I wound up at Enron, and I started out working with their JEDI portfolio, which is a commodity-based asset. And I worked my way up the corporate ladder to eventually become Vice President of Corporate Development.
Wow, that's a lot of qualifications. Could you please tell us about the company culture at Enron?
Enron is unique in the sense that it has a very unique company culture. It felt almost like a survival of the fittest situation. We were encouraged to do whatever we could to win, to be the best. If you had to step on people's throats to get there, you stepped on people's throats, you know. It was very intense, and it was unique in that way.
All right, and can you describe what it was like being under the management styles of Ken Lay and Jeff Skilling specifically?
Ken Lay and Jeff Skilling were both very charismatic people. When Jeff Skilling came into the company, it was almost like a knight in shining armor. It felt too good to be true. Both of them were very driven, and they wanted our company to continuously evolve and change. But they definitely did enforce that company culture of survival of the fittest. Do what you can. Reputation is everything. If you have a poor reputation, you have a higher chance of being terminated. So working under Jeff Skilling and Ken Lay, it was a stressful situation.
Yes, awesome, thank you. And then what is off-balance sheet accounting?
Off-balance sheet accounting is a style of accounting that is accepted by GAAP. They do this in order to remove liabilities, assets, stockholders' equity from our balance sheets. In most cases, this would be for, if it's not an asset, liability, or stockholders' equity that's owned by the company. So if you have a client whose investments you don't want to list on your balance sheets, that's when you would take them off, and that would be off-balance sheet accounting.
Thank you, that was perfect. And how did Enron abuse this off-balance sheet accounting?
Enron, what they did was they removed liabilities from their balance sheet.
Objection, Your Honor. Waiting.
Can you repeat the question?
Yes, how did Enron abuse off-balance sheet accounting?
I'll overrule since she'll expand on my question other than that, correct, yes or no? Thank you.
So Enron used off-balance sheet accounting to hide liabilities. With their special purpose entities, it made it a little more confusing, but in total, they were removing their liabilities from their balance sheet in order to maintain their debt to equity ratio. So in turn, this maintained their ratio, which inflated their stocks, which made the company look like it was doing well, when in reality, we had billions of dollars of debt building up that we weren't showing on our balance sheets.
Yes. And then can you explain your interaction with Ken Lay when you brought up your specific concerns with this off-balance sheet accounting?
I originally brought up my concerns in an anonymous memo, and then when that wasn't answered, I created a face-to-face meeting with Ken Lay. And pretty much I brought to his attention how I had noticed some irregularities in our financial accounting. That would be our off-balance sheet accounting. And then working specifically with JEDI when I first got there, I had some experience looking into our SPEs, our special purpose entities. And that's when I noticed how it was kind of masking a lot of our debt, and we were using our SPEs incorrectly. So this is when I brought up to Ken Lay our best case scenario would be to come clean to the public. This would not help the company, but be best case scenario for our company. When we were looking at our SPEs and all of our debt, we had no insight for our long run agreements, and it was all just short-term profit. So that's an issue when dealing with our company accounting.
Wow, it's great to explain it, isn't she? What happened after you talked to Ken Lay about this?
He told me he would take into consideration and look into it, and then a few weeks went by and nothing had really changed with any of our accounting departments. So yeah, I decided at that point it was time to report it to a higher up, since my bosses weren't doing the correct thing. And that's when I reported to the SEC, later to find out that Ken Lay and Skilling had debated firing me after I brought up those concerns.
Awesome, no further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Isn't it true that after raising concerns about Enron's accounting, you remained at the company and continued to collect your salary?
I did.
Before writing your memo, you had never personally passed over promotions or other opportunities at Enron, correct?
Correct.
Did you benefit financially from your stance taken against Enron?
No.
Are you sure?
Yes.
Okay. Your Honor, permission to approach the witness with what has been marked as Exhibit D.
Do we have Exhibit D into evidence at this time?
Yes.
Do we have?
Oh, you mean has it already been submitted into
Yeah.
evidence?
Oh, no.
No, we did see.
We did C, so now it would be Exhibit D, I believe, yeah.
You can, lay foundation so we can enter that.
Okay,
Yes.
thank you.
So just a little bit more on where you were going to lay the
Yes.
foundation.
So Ms. Watkins, you just said that you have not personally benefited financially from your stance taken against Enron. You've written a book,
I have.
and have you made money off that book?
I have.
So you made money off your stance taken against Enron?
Off the book.
That you take a stance against Enron. Ms. Watkins, I have read the book. Permission to approach Ms. Watkins with what is marked as Exhibit D.
You may.
Here, Ms. Watkins. And just in advance, I will give you all a copy as well. All right, here we go. Ms. Watkins, Ms. Watkins, do you recognize Exhibit C?
This is the book.
This is the book, correct. So that you just laid the foundation, thank you. Did you create Exhibit C?
I did.
The defense moves to enter Exhibit D into evidence. Thank you.
We'll do any objections first.
No.
The jury will accept Exhibit
Deep breaths.
D.
Ms. Watkins, can you please read the following highlighted lines of your own book, the end of page 35, starting with Ken Lay?
Ken Lay was a man who did not like to say no. His employees soon learned to exploit his weakness. His people performed, but they also extracted their pound of flesh, most often in the form of large cash rewards.
So, Ms. Watkins, individuals at Enron would exploit and try to take advantage of Mr. Lay, correct?
Correct.
Ms. Watkins, in your book, you reference doing things like smiling like a girl and acting naive. Would you consider those types of things manipulative?
Sure, yes.
All right, Ms. Watkins, you are aware that SOX, which holds executives accountable for financial disclosures, was not enacted until 2002 after Enron's collapse, correct?
Correct.
And Enron's financial statements were reviewed and approved by Arthur Andersen, one of the top accounting firms in the world at the time, correct?
Correct.
If the fraud was obvious, why didn't auditors raise serious concerns earlier?
There was a conflict of interest with our auditors. Arthur Andersen was directly combined with Enron. A lot of the time you could tell if Arthur Andersen employees were being employed.
Did you have
by
knowledge
Arthur.
of this?
I did not.
And isn't it true that the SEC had not explicitly declared Enron's practices illegal at the time that they were being used?
Correct.
The defense rests.
Any redirect?
No redirect.
You may step back. Prosecution, do you have any more witnesses you'd like to call to the stand today?
No more witnesses.
With reference to Mr. Holman, are we doing no more today?
Correct, we'll do no more calling witnesses, we'll just, maybe kind of get your debrief comments for day two, I'll chime in a little bit too. We'll let the jury update their rubrics where they're at. Do be sure to put your names on them, I'll collect them and give them back to you